North Carolina and Florida, as well as in all other states with local co-counsel. She handles complicated child custody cases for protective parents, as well as other civil and criminal trial court cases. She's been practicing nationally since 2002, and she has been counsel for a federal ERA case.
Hello, can you hear me?
Yeah.
Okay, great.
Now come closer.
Okay, can you hear me? I feel like I'm kissing the mic. Okay, so my name is Arlene Rocky, and in case you might need to Google me, Rocky has an EY in it, and you can also just Google Rocky ERA. And the reason to do that is I have an ERA legal blog on my website, and I'm a lawyer and I'm into evidence and proof and legal reasoning. And in the blog post that I have from the one before this last one, the one on 1/28/2024, the basis of that was a letter that I sent to the White House counsel and also many other top people in the Biden administration. I'm going to back up just a tad. Some of you may know my sister, Virginia Polaris. She's also an attorney. She ran for Congress in the Asheville area a couple years back. Don't expect her to run again. I don't think it's very hard to do. But she has been co-counseling with me on the ERA cases. So how I first became involved in this is a former client called me and said that she was an amicus, like a friend of the court, in the equal means equal federal ERA case that they had just filed. And they filed a case in January of 2020, which was the same month that Virginia fully ratified, was the final state, 38th state, to ratify the ERA. Yes, but it's been 4 years. And the last thing that has to happen is for it to be published in the Constitution. So right after that happened, actually it was right before it happened. Pardon? It's the Federal Register that is put it in the Constitution. People don't know what that is. But yes, the Federal Register, and that puts it in the Constitution. And the archivist has to certify that all those 38 states actually ratified that amendment, which had already been done. It's already been done. In fact, there's a link on my blog post, and I also have an opinion article that just came out in the Daily Cause, KOS, and it has the links to that stuff too. And what it says is Biden published ERA. Okay, I'm going to get to that in a minute. But first off, the first person who blocked the ERA was President Trump, one, by appointing 3 justices, and 2, right before Virginia was about to vote, Bill Barr, who was his Attorney General, went to the Office of Legal Counsel in the Department of Justice and asked for an opinion letter that said that the deadline that was put in the prologue of the ERA, not in the actual text of the ERA, by the Congress was a valid deadline, and it was a 7-year deadline for all the states to ratify. And then they expanded, this Congress thought they could expand it, and they expanded it for 3 years. And what happened is it's Phyllis Schlafly. How many of y'all have heard of Phyllis Schlafly? Woo! And there's a, Mrs. America is a documentary on it. I can't remember which, I think it's Hulu. But you can watch that and find out what all happened from her end. But anyway, they found that they told the archivist that the archivist could not publish because the deadline was valid. Well, the deadline is not valid. The deadline is unconstitutional. There's an attorney in Chicago, Michelle Thorne, who did a legal analysis based on Scalia's very conservative textualist and originalist interpretation methods, and determined that the deadline is unconstitutional for a few reasons, mainly because Article 5 cannot give Congress the power to put a deadline in its text in the Constitution, and 2, because it violates the 10th Amendment. The ability to put a new amendment in is supposed to be shared power between the states and the federal government. And anything that is not specifically given to the federal government is reserved for the states. so it violates both of those laws. So anyway, we took on the job of being attorneys, and I had another friend of mine who graduated from Chapel Hill with me to be co-counsel as well, and we filed an amicus brief in the three courts where Equal Means Equal had been suing to get the court to tell the archivist that archivists shall publish. The archivist there's a law, which y'all should remember this law. It's 1 U.S. Code 106B. And the reason why you should remember it is because the president and all presidents have a duty to take care that the laws are faithfully executed. That means faithfully enforced, followed through. And so our president, Biden, has a take care duty to publish the ERA based on 1 USC 106B. And he has not done that, okay? And if he did that, which is just this is what this white sheet is for. It's a project of Equal Means Equal, and it is trying to tell people that Biden just needs to pick up the phone. It's Make the Call Joe. That's the name of it, Make the Call Joe. If he would call the archivist and tell her to publish the ERA, she has to publish it. In fact, that is specifically one of the types of things he can do with an executive order. He likes those, and he's also promising what he's doing with executive orders, and then he has not done this. When the Dobbs case was coming down, I listened to the oral arguments. Am I the last one or not?
No, I've got 1 minute.
I got 1 minute, okay. So I wrote a letter after I got the Alito leak, and it said there was nothing in the Constitution textually that required them to allow abortions. The problem was the ERA was not published in the Constitution, so they didn't have notice that it was an amendment. They didn't have legal notice, and the lawyers for Dobbs would not tell them that the ERA was legally the ERA. Okay, and that is horrendous. Okay. But I contacted them and hunted them, and they didn't do anything. So Gina and I, for ERA and Sea Alliance, who's the co-sponsor of this project today, this gathering, we represented them, and we filed a motion in the Dobbs case asking for permission to file a brief on the ERA in Dobbs, specifically because it does have the legal basis for abortion rights and reproductive rights, and it also creates a fundamental right. And it also, even though it's not been published, if he publishes it and they get notice, then Biden publishes it, that they can overturn Dobbs. It's that strong, and it will get rid of the Comstock.
Yeah.
So you need to go around telling Biden to publish the ERA.
Yeah.
And look on my website. I also am Marlene Rocky on Twitter or X. And I would say your chance if you're marching should be Biden publish the ERA. ERA is the only way, because Congress has to have a constitutional reason to make a law. So they cannot codify Roe until Biden publishes